Tobago against Trinsalvage Enterprises Limited.
Mr. Rowe.
Thank you, my Lord.
Give me just one moment, if you would.
Of course.
And thank you all for accommodating our need to start slightly early this morning. We propose to take a 5-minute break because it's a 3-hour session at the end of Mr. Rowe's submissions, which seem to come just over halfway through.
Very well, my Lord. My Lord, as your Lordship and your Ladyship will have seen, I appear on behalf of the appellant. The respondent is represented by my learned friend, Mr. Ramesh Maharaj, Senior Counsel, as well as by Anand Singh, Mandavi Tiwari, Vijaya Maharaj, and Michael Rupal. My Lord, the appeal presents a question which might almost be an exam question.
Yes, we thought so too.
Where an Act of Parliament expressly provides that only a particular body may invite and accept offers for the supply of services or goods to the government. But the government and a private body do not follow the Act and instead purport to contract without regard to the Act, and the private body does the work to the benefit of the government. Can the private body nevertheless recover the same sum in practice to which it would have been entitled if the Act had never existed? That essentially is the question presented by the appeal. As your Lordships will have seen, the courts below answered that question affirmatively. The appellant before the board respectfully submits that they were wrong to do so. And as I say at the very outset of our written case, we accept that in a number of respects that is an unattractive position because it would leave the respondent without recompense for work that it did. But we respectfully submit that is the answer which is compelled by the law. My Lord, the scheme of the submissions that I propose to make, and it may be, well, I shouldn't perhaps make promises that I can't necessarily keep, but it may be I can get through it, in fact, in a little less than an hour and 45 minutes, but we'll see. I'll do my best. The scheme I propose to adopt is, first of all, to take the board to the facts, which, as befits an exam question, are brief and uncontroversial. Then briefly to the judgments below, then to the Act itself and some of the authorities that speak about the principle of not granting a remedy which stultifies the Act, which I think broadly agree is the right principle.
Yep.
And then to come on to explain why we respectfully submit that the Court of Appeal, and indeed the judge at first instance, reached the wrong answer. And as part of that latter exercise, I propose to follow essentially the scheme of our case, where we've identified 6 respects in which we say the Court of Appeal went wrong. Of course, the ultimate question is one of law, so in a sense it doesn't really matter whether the route by which the Court of Appeal got there was right or wrong. What matters is the answer to the question, but it may be that in the exercise of going through the various respects in which we submit the Court of Appeal was wrong, matters the Court of Appeal overlooked and so forth, I can illuminate why it is I submit that the right answer is the one for which the attorney contends. So, my Lord, as far as the facts are concerned, they can be taken, I think, straight from the Statement of Facts and Issues, which the board has, starting at page, I think, 423.
Yes.
And we've expressed them over just 4 paragraphs, starting at the bottom of page 424. Permanent Secretary at the Ministry of Works desired to carry out and complete various projects within the Ministry's portfolio in relation to a harbour at San Fernando. Permanent Secretary purported to accept in writing on behalf of the Ministry an offer from the respondent to carry out certain coastal reclamation work, which we accept the Ministry wanted done for proper public purposes at San Fernando Harbour, for a price exceeding 250,000 Trinidad and Tobago dollars, which is relevant because of an exception in the Act to the requirement to involve the
Can you
Central
remind us what kind of dollars are we talking about? US
These are Trinidad and Tobago dollars.
And what's the rough conversion rate?
it's not quite divide by 10, but it's
Okay.
more or less that.
Yeah.
As is now agreed, by virtue of the Act, only the Central Tenders Board in fact had authority to do that, to enter into the contract, that is to say, on the government's behalf, or indeed to invite offers and accept offers.
Can I just check with you? I think it's accepted in here that it was for the ministry to decide whether the work needed to be done, rather than the Central Tenders Board. Is that right?
My Lord, essentially that's right. Although there's as we'll see from the Act, there is in practice a sort of filter because it has to go through the Central Tenders Board.
But it's not for the ministry to go and say, well, we quite like these harbour works to be done, and the board to say, well, no, we don't think they need to be done. No,
I mean, plainly the board, well, it's not spelled out on the face of the Act, but one on a sensible reading, plainly the Central Tenders Board couldn't say, no, as a matter of policy, we think you should spend the money on something else. But equally, in an appropriate case, as I will come on to submit, the Central Tenders Board might say, well, hang on, does that really need to be done? I don't say that this is such a case, because we accept this was work that was wanted to be done for a proper public purpose by the minister or by the ministry. And as we go on to say in the statement of facts and issues, therefore there was no valid contract because the Central Tenders Board hadn't been involved. The respondent carried out the work. I should also add to this, I think is common ground, that sums were in fact paid pursuant to the purported contract, but not all of the sums that were...
How much was paid?
I'm afraid I don't have the figure at my fingertips. I'll have to come back to you on that, I'm afraid. Architects' certificates were obtained and submitted to the ministry under the purported contract to the effect that work had been done for which a payment of a total of nearly 5 million Trinidad and Tobago dollars was warranted, and the ministry didn't pay. And that's the sum that's in issue in the present case, which is just shy of £600,000 if one wants to look at it in comparative terms.
So it's purely the variations that come to that sum.
I think that's right, my lord. Yes.
The principal sum is not an issue, and we don't know what that is.
That's right.
Is that an admission or agreement that the certificates were obtained for that full amount?
Yes.
Right.
There is. Well, as we go on to explain in the paragraphs of the Statement of Facts and Issues, the way in which the parties dealt with this issue was, that is to say, the value of the works, was to say that although these were certificated sums under the contract, or they would have been if there had been a contract, the way in which the value of the work should be ascertained was by going to an independent expert. And the parties essentially agreed, very sensibly, that the independent expert would value the works, and if the court said their...
Can you just help me? What is the yardstick that the expert is using? That it's due under the contract, or that it increases the value of the ministry's land by the relevant amount, or that that's a reasonable price to have paid for it? What sort of yardstick is the architect using when certifying?
As I understand it, the yardstick is the market value of the works. In other words, what would have been payable under a contract,
right,
for the work, which didn't specify, as is of course common in building cases, which in far as variation doesn't specify in the contract what the figure is, but says,
well, I mean, yes,
there's some mechanism for working it out by reference to the market value of the works.
Okay.
Well, that's a different thing from the architect certifying that a certain stage in the construction as set out in the contract has been achieved, but this is the market. This is what someone would reasonably have paid for the work that's been actually carried out.
It's basically just additional landfill, isn't it?
I'm sorry, I didn't catch that.
It's additional landfill, that's what it relates to, as I understand the pleadings.
Yes.
Which are omitted.
So, as we say at paragraph 12 and following, just to pick up on the litigation history, the respondent sued the appellant, seeking payment of that sum of nearly $5 million. Seeking it primarily in contracts, the appellant took the point that the Permanent Secretary hadn't had authority to bind the government, and the parties thereafter invited the court to determine that issue as a preliminary issue. And we see the reference to that at page 14 in the record.
Can I just be clear? Paragraph 14, the agreement is that an expert will be jointly appointed to value the works. That is on a non-contractual quantum merit basis. Is that right?
It's not spelled out like that on the face of the consent order, but that's certainly how we understood it to be.
Paragraph 5, the last sentence. The issue of quantum can be determined by the appointment of a joint independent expert to ascertain or determine the valuation of the works done.
Sorry, where's your lordship reading
I
from?
beg your pardon, I'm reading from the last sentence of paragraph 5, the document you've just referred us to, on page 17 of the electronic bundle.
Sorry, we're on the statement of agreed facts here, aren't we?
Yeah, the statement of agreed facts refers to the reference given in the statement of agreed facts at paragraph 14 of the statement of facts and issues is to page 14 in the record. And if I can ask your lordships to go there, that's the consent application by the parties. So your lordships will see that, and your ladyship will see that they agree.
Be determined by the appointment of a joint independent expert to ascertain or determine the valuation of the works done.
That's the last sentence of paragraph 5 that I referred you to a moment ago.
Of the grounds of the application, that's right.
Yes.
But by the time of this agreement, reflected in this consent order, there was a pleaded claim in the contract and in the alternative in quantum merit, as I understand it. Yeah.
Right.
And this needs to be read in the light of that.
Well, that's right. And as you can see from page 14, the grounds of the passage that we've just looked at, the paragraph 5 and so on, that's set out under the grounds of the application.
Yes.
It's put more concisely in the application itself on page 14, where you'll see, first of all, there's dispensing with the need for evidence in support of the application, and then the two issues, paragraph 2, are disposed of be disposed of as follows, and the first presents the question of law. Because at that point it was still live between the parties whether there was a contractual claim as well.
Yeah. I see.
And they agreed for that to preliminary issue. And then little Roman 2 of paragraph 2, in relation to the issue of quantum, the parties agreed to appoint a joint independent expert to determine or ascertain the value of the works. In ascertaining the quantum if necessary, and the parties agreed to be bound by the valuation of the joint independent expert.
So Roman 2 on page 18 is the of the electronic bundle.
Yes.
Yeah. Yes. Well, that's the end of the application. I'm not sure it makes any difference, but that's at the end of the section entitled "The Grounds," starting with the grounds of the application.
But presuming an order was made.
A narrative explanation of why they're asking for the order at 14.
And there's an order presumably somewhere in the bundle in terms of that application.
Yeah. Well, I'm not sure whether it's made into the bundle, but we all agree that's what the court.
Right.
That's the basis on which the courts below were acting.
Yeah, so then in answer to my query, it's not clear that one is talking solely about a non-contractual quantum merit. It might actually be a contractual quantum merit.
I think on reflection, my lord, that must be right, because at that stage...
Thank you very much.
But both were possible grounds of recovery.
But now that it's agreed that the contract was void, does that drop away the potential for it to be a contractual quantum merit?
Well, it can never be. Yes, I mean it can't be. The question for the expert can't be under the terms of the contract what sum is due. Assuming the contract talks about a reasonable sum or leaves it silent and one implies it's a reasonable sum. but there remains, of course, the issue of what is the appropriate figure for the quantum merit. But as I accept, it's not spelled out on the face of it how that is to be determined, but by implication, we would submit what the expert is being invited to do in valuing the works is to value their market value. He's not being asked, or she's not being asked, to say to what extent has the government's land been increased in value, for example, or any other basis. The way in which the courts below dealt with the issues can be taken also fairly briefly, because so much has fallen away. The judge at first instance, Justice Sipasad, gave judgment on the 7th of January 2014, and much of the judgment is concerned with the contractual question. But for present purposes, can I invite the board to pick it up at page 102 in the electronic bundle. If you've got the key documents printed out separately, it's the last document, number 8. So up to this point, the learned judge has concluded that there's no contract, and the question is then posed, is the claimant left without any recourse? There was an initial pleading point that was taken but was brushed aside and is not thought to be revived. And the next few pages I think invite the board to skip over, because they simply set out what one might call, as it were, the ordinary law of restitution in this context, or unjust enrichment, explaining how it is that where a contract is void, the person who has provided services purportedly pursuant to it may nevertheless be able to recover the value of the market value of those services. The critical point for present purposes, of course, is, does it make any difference that, in this case, the reason that there was no contract is the existence of the Central Tenders Board Act and the failure to follow its provisions? That isn't addressed at first instance in very direct terms, but the substance of the relevant reasoning, your Lordships and your Lordship can see at page 107 in the electronic record. And it really starts at the bottom of that page, or towards the bottom of that page. In the instant matter, your Lordships have that, the work undertaken between 2001 and 2004 was done in a very public location. The defendant admitted the fact of the work, and in the filed statement of agreed facts, it was stated that the defendant was aware of and accepted the claimant's services. In the view of the court, it cannot be rational to conclude that although substantial work is undertaken which ultimately benefited the public and the people of Trinidad and Tobago, and therefore the defendant, the cost associated with the said work is not to be addressed. It was clear that the claimant did not agree to undertake the same free of charge, and that the value that could be attached to the same is significant. And then the judge then expressly addresses, albeit briefly, the fact that it was ultra vires the provisions of the Central Tenders Board Act. Although the Permanent Secretary acted ultra vires the provisions of the Central Tenders Board Act, in entering into a contract with the claimant, that work was subsequently effected over an extended 4-year period in a public place, essentially making the same point. Insofar as the work was done on property belonging to the state derived a benefit from the said work. This court therefore holds that the state has been unjustly enriched, and the claimant is therefore entitled to recompense. And then your Lordship see the order that's made by the judge at first instance. Claimant is entitled to be paid for work on a quantum merit basis. Parties to appoint a joint expert within 28 days to determine and or ascertain the value of the works undertaken by the claimant. Defendant to pay whatever sum the expert comes up with. So that was the judgment at first instance. The case went on appeal to the Court of Appeal on not only that issue but also still the contractual issue. But that part of the appeal didn't succeed, and we don't need to consider it any further. What's relevant for present
So that
purposes?
was a cross appeal on the contract.
I'm sorry,
Cross appeal on the contract.
There was a yes. Yeah.
You appealed on quantum merit, they cross-appealed
Yes.
on contract. Yeah.
Isn't, just before we leave, Mr. Justice Supersad, isn't page 101 in the electronic bundle, page 20 of the decision, rather important in terms of the policy?
Yes, my Lord, it is. I was going to come back to it in the course of my criticisms of the Court of Appeal for the way in which they characterised the Act, but since your Lordship mentions it now, I'm happy to deal with it now, of course. My Lord, entirely, we respectfully agree, and we place some emphasis on that. It's the passage, most of the passage in bold on page 101. In particular, no doubt your Lordship has in mind, the Court wishes to point out that Parliament enacted the Act so as to ensure that proper procedure characterised by transparency and fairness is adopted and adhered to in the procurement process. The effect of the Act is to regulate the conduct of officers of state and to ensure that contracts are not awarded on an arbitrary or self-serving basis by persons such as ministers who are entitled to contract on behalf of the state at common law. If the spirit and tenor is rigorously followed, many of the unfortunate allegations of kickbacks and financial impropriety that have been levied against successive governments would be curtailed. Then the Court goes on to suggest that the Act ought to be revisited. There's no penalty for default by permanent secretaries or ministers who do not follow the procedures laid down in the Act, or any provision for the imposition of penalties and deficiencies ought to be addressed, says the learned judge. But, my Lord, yes, we do respectfully place some emphasis on that as a correct statement of the purpose of the Central Tenders Board Act. So, my Lord, as I was saying before, I was helpfully diverted from going on to it by Lord Burrows. The Court of Appeal also, of course, dealt with the issue of unjust enrichment, and perhaps I can invite the Board to pick it up at page 193. This is not quite where the reasoning begins, but for present purposes it may be may be helpful. 23 in the judgment in the learned Justice of Appeal in the Court of Appeal. Justice of Appeal Barrow, with whom the others agreed without adding anything, I have carefully considered the provisions of the Act, and I can discern no policy within the provisions of the Central Tenders Board Act, express or implied, which will be stultified if the claimant succeeds in his claim in unjust enrichment. The Act establishes the Board, but its provisions do not show any underlying intention to prohibit the enforcement of the rights of an innocent party who has entered into a contract which is ultra vires its provisions. I consider that the limitations placed on the Permanent Secretary's power to contract appear at best to be for purely administrative convenience. I would also have expected that the Act would have explicitly prohibited the enforceability of any legal or equitable rights arising out of any contract which was out with its provisions. And then there's reference to some other authorities, which I will, if I may, come back to later on. So, but that's essentially the core of the reasoning of the Court of Appeal. Essentially, I submit that's the core of it. Essentially, the limitations placed on the Permanent Secretary's power, as it's put in the judgment, are at best for purely administrative convenience, and it's relevant that there's no express provision prohibiting enforcement of other rights, that is to say, other than under the contract. So, Lord, can I, with that brief introduction to what the courts below said, then ask the Board to look at the Act itself to start with? And we can find that in the bundle at page 482. As I think we've explained in the Statement of Facts and Issues, although it's now the Central Tenders Board Act, it in fact started life as a pre-independence ordinance, which was then given, along with a number of other ordinances, given specific effect as an act in 1980. and it's been amended from time to time, but it's, as far as we can tell, here in the form that it was at the time of the events that we're concerned with. You can see the date of the 1st of January 1965 on page 486. For present purposes, I think we need to pick up at section 4, really the core of it. There is hereby established, that's page 487, there is hereby established a Central Tenders Board which, save as is provided in section 20A and in section 35 of this Act, which we agree are immaterial exceptions. We can look at them briefly in due course if we need to, but they don't affect the central point of section 4, which therefore shall have the sole and exclusive authority in accordance with this Act to act for and in the name and on behalf of the government and the statutory bodies to which this Act applies in inviting, considering and accepting or rejecting offers for the supply of articles or for the undertaking of works or any services in connection therewith necessary for carrying out the functions of the government or any of the statutory bodies, or to dispose of surplus or unserviceable articles belonging to the government or any of the statutory bodies. And then section 5 tells you what the board actually is, composed of 8 members consisting of at least 5 public officers appointed by the President, such other members at large to be appointed by the President as may be necessary to fill up the membership of the board. The President shall appoint 2 of the ex officio members of the board, other than the Treasury Solicitor, to hold the offices of Director of Contracts and Deputy Director of Contracts, respectively. And there's more detailed provision about exactly who does what. And then there are further detailed provisions that I didn't think I need take the board through in detail, but it all sets out in some detail how it's all to work. Importantly, for present purposes, regulation section 12 requires there to be meetings of the board. Section 12, subsection 4, on page 490, requires the meetings to be minuted and certified by the chairman at the next succeeding meeting. There are provisions at section 13 about what constitutes a quorum. And then the procedure for the obtaining of articles or works for the government is spelled out in more detail at section 20 on page 492. Subject to section 19, which is about a committee of the board, a subcommittee effectively that can be delegated to deal with certain more minor procurements. Whenever articles or works or any services in connection therewith are required to be supplied to or undertaken on behalf of the government or a statutory body to which this Act applies, the government or such statutory body shall make written request to the board to invite on its behalf offers for the supply of those articles or for the undertaking of the works or services in connection therewith. And subsection 2 tells you that it has to contain a sufficient description. And subsection 3 tells you what the board then has to do. It can invite members of the public to make offers by notice published in the Gazette, or it can invite persons selected by the board, subject to the approval of the minister, to make offers. One of the exceptions is at section 20, capital A, page 493, which allows the government to act on its own behalf in certain limited circumstances. And the other provision I wanted to take the board to is section 23A. The board shall not accept any tender unless it is accompanied by a tax clearance certificate and a clearance certificate issued under the Income Tax Act. And and the Value Added Tax Act, respectively, and obtained from the Board of Inland Revenue. We haven't delved into the precise definition of tax clearance certificate under the Income Tax Act or the Value Added Tax Act, but as we say in the agreed statement of facts and issues, the effect of Section 23A is that the Board is forbidden from accepting any tender unless the tender is accompanied by information showing that the tenderer has complied with its fiscal obligations. And the public policy behind that need scarcely be spelled out. Section 26 explains what is to happen once the Board has accepted an offer. That's on page 497. Where an offer has been accepted by the Board or a committee acting for and on behalf of the Board, the government or statutory body at whose request the invitation to offer was issued and the person whose offer has been accepted shall enter into a formal contract for the supply of the articles or the undertaking of the works or services as the case may be. A formal contract shall be in such form and contain such terms, conditions and provisions as the Board may determine. The Board shall publish in the Gazette the name of the person or body to whom the contract is awarded, the amount of the tender and the date on which the award was made. So although it's right to say that the Board itself doesn't enter into the contract, the government does. The government can't do that under the Act unless the Board has accepted the offer and the Board has determined what terms, conditions and provisions the contract shall contain. There are also regulations made under the Act, the Central Tenders Board regulations. I don't think we need to go into those to any great extent. Just for your Lordship's note, Section 12, Regulation 12 of the regulations contains a further, as it were, de minimis exception. The text that we've got says that the figure is $1 million. That's to say a permanent secretary can act for the Board, permanent secretary of the government, in the government can act for the Board, where the total value of the articles to be supplied or the works or services to be undertaken does not exceed $1 million. I think we agree that at the time of the contract in the present case, or the purported contract in the present case, the figure was $250,000.
What was the page of Regulation 12 in the bundle?
Sorry, my Lord, I should have said it's 511.
Thank you.
So at the time, A and B had the same.
No, because B is $25,000. I don't know what B was at the time.
Oh, sorry, and what did you say A was?
A at the relevant time was $250,000.
Oh, 250,000, thank you.
And again, one can see the scheme at work in sections A and B there. So a permanent secretary or the chief administrator of the Tobago House of Assembly get a sort of hired authority to a greater extent than a mere officer appointed under the sub-regulation. It's obviously designed to ensure that really small contracts don't need to burden the Board, and bigger contracts can also be dealt with by the permanent secretary, but only up to a still relatively low limit. One bears in mind, even now, a million Trinidad and Tobago dollars is a little north of £100,000. So those are the relevant provisions of the...
Is there anything in the Act or the regulations that deals with future variations of the contract, an agreement to change the works or change the contract price?
Not that I've spotted, my lady, no.
But, or is there always something in the terms and conditions that the board specifies for the contract? Some limitation on future variations? Do you know?
There's certainly there's certainly nothing in the Act, lady, and I can't. I think with any confidence tell the board what happens in practice. But I suppose if one thinks about a conventional building contract, for example, the contract will of course have provision for variation and how. I mean, it's trite, of course, isn't it? When in a building contract, when the contractor says, look, this is going to take far longer than we thought because we've dug the ground up and discovered it's harder than we thought, or whatever it might be, there is a mechanism usually in the contract for dealing with that. And one would expect, therefore, that the board, when approving the terms of the contract, would have in mind that it should have provision in it for dealing with that sort of thing. I'm afraid what I don't know is whether in practice, I can find out if, I can certainly ask whether I can assist any further, but what I don't know is whether in practice the board has a particular modus operandi as regards that sort of issue. But one might expect, for example, that the contract would say that the power to vary it by, or the power to vary the price under it by reference to the architect is limited to variations up to a certain value, and that above that, the parties need to go back and reconsider the matter. And of course, if that was the position, then it would have to go back to the board.
And to be retendered, because the board doesn't seem to have any alternative but to tender, or to put a contract out to tender. Not always a public tender, but even the private process is described as being in the plural.
Yes.
I suppose deliberately doesn't include the singular.
Yes, although there's the power for the board to. Yes, I mean I'm not sure the point has ever been tested. What would happen if halfway through the works a further contract was needed? Would the board really be obliged to?
Well, you wouldn't re-tender for a variation of works, would you?
No, I mean that would be odd.
Providing, I'm assuming that in the absence of a competent variation clause, if the board had already approved a contract with a variation clause in it, then
that problem doesn't arise. I agree.
Yeah.
I agree. Yes. What would happen if there was no competent variation clause? May perhaps be left for another day.
Yeah.
So, your lordships have already seen in the judgments below the way in which the contrasting ways in which the judge at first instance and then the Court of Appeal described the underlying rationale of the Act, and we respectfully submit, the attorney respectfully submits that the judge at first instance was closer to the mark. Indeed, it's well wider than the mark we submit to say that this is simply for administrative convenience. Indeed, it's rather inconvenient on the face of it to have to involve the board in this process. Much more convenient from the government's point of view would be the capacity simply to say this is who we'd like to do the work and we're going to sign the contract tomorrow. What the Act is really about, as the judge at first instance recognised, is ensuring that the powers that the government has to spend the public's money on works are reserved to the members of the Central Tenders Board, who are independent, tenured, and heavily scrutinised. The reason it does that is because, of course, those powers are ripe for, at best, improvident exercise, and at worst, outright abuse and cronyism. So, I respectfully submit this Act, far from being administrative in nature, is essentially constitutional, because it addresses a fundamental issue. And the reason I say it's constitutional is because it's about the allocation of governmental power. It takes powers away from the government, in the sense of the ministers, puts them in the hands of this independent board. So, my Lord, before I come on to address the respects in which we say that the courts below, respectfully, we say got it wrong, may I just take the board then briefly to some cases about the principle of stultification, because we agree that the Court of Appeal essentially identified the right question. Would allowing the claim stultify the Act? That is to say, would it make a nonsense of the Act? But it may be helpful just to expand on that a little by looking at some of the material which, or some of the cases which bear on that question. The first of them is
Just before you go there,
Yes.
so you are not challenging that there is what one might call a prima facie unjust enrichment claim. You're accepting that the sole issue is, assuming you've got a prima facie claim, is it knocked out or stultified by the policy of the Act?
I suppose that's right, my lord. That's perhaps a slightly claimant-friendly way of putting the question, possibly, but that's it might be said. But essentially, yes. I mean, I agree. There is the issue is whether allowing the claim would stultify the Act, and I suppose self-evidently the premise of that is that if it wouldn't, then the claim succeeds. So.
I mean, what I mean by that is you're not challenging that there is otherwise the ingredients of an unjust enrichment claim made out in terms of unjust factor, benefit at the expense of.
No,
that is not being challenged.
No, that's not. That all of that was gone into by the Court of Appeal, and we don't say the Court of Appeal got that bit wrong.
Thank you.
Although, I mean, well, it's I qualify that very slightly. I'm not sure if I need to make this qualification, but I'll come on to it in the course of my criticisms of the Court of Appeal. It's important in this case to keep in mind, we submit, this is not like a case where there is what in every other respect would be a contract between the parties, but there is some formality, say, that's been overlooked in the course of making the contract. There's a rather more fundamental problem here, which is that the Act says explicitly that the only body with any authority to contract on behalf of the government is the Central Tenders Board. So that's important because in some of the reasoning below, and I think in our learned friend's reasoning in support of the decision below, it said, well, the government did ask for this work. Well, the minister asked for this work through the permanent secretary, but in the constitutional scheme of things, the organ of government which asks for the work is actually the Central Tenders Board.
But that may not be if it's variation work.
Well, I'm not sure I follow you. I'm not sure I follow your lordship's
Well, I'm sure that it
observation.
wouldn't necessarily be the board who would be asking for or approving variation work.
Well, I can see that the case. I suppose the case might arise where the board had agreed a contract and then subsequently the government went out with the terms of the contract to purport to agree a variation. But here we're concerned with the contract which the Central Tenders Board never had anything to do with in the first place.
Yeah, I mean, you say there isn't a variation clause.
There's no
which
contract.
binds government, or entitles government in this case, because there isn't a contract.
That's right.
Anyone.
There's no contract in
been entered into.
Yeah.
Yeah.
There's no contract in the. What's happened is that entirely outside the scheme of the Act and without any authority to do so, under the scheme by virtue of the scheme of the Act, the permanent secretary has said to the respondent, "I propose to spend some public money on getting you to do this work," and they've done the work. But there's no contract there at all, and the whole thing has entirely circumvented what Parliament has said ought to have been done.
Do you, I mean, you phrase that in terms of whether the government can be regarded as having asked for the work. What about standing by and allowing it to go on, accepting it, if you like? Is that, are you making the same point, or is that a different point?
I think that's a slightly different point, my lord, because I think I would have to accept that plainly the minister knew that the respondents were beavering away, doing the works on the harbour, and it's accepted common ground that the work was work that the state benefited from.
Thank you.
But that brings us back, of course, to the central question in the appeal, which is whether that's enough to allow one to, as we would put it, to outflank the statute. So, my lord, I was just going to go briefly to some of the authorities that deal with this, and the Haugesund case is the first one that I wanted to take the board to. The passage that's the case that the board's familiar with. It starts at page 611. It's the case in the Court of Appeal in England and Wales about swaps contracts in Norway, and it deals with a number of issues. But for present purposes, what's interesting is what's said there about public policy. And perhaps I can invite the board to pick it up at page 645, the scope of a public policy defence to a restitutionary claim. This was, of course, a claim about return of money. So for reasons I'll develop in a bit, if I may, this is a bit different from the present case. This is, I think we're looking here at the judgment of Lord Justice Aikens. And he says there's no doubt in English law that a restitutionary claim for the return of money may be defeated on grounds of public policy, where on the correct construction of a statute or regulation, recovery and restitution would be contrary to the objective of the statute. And some examples are referred to there. The Boissevin and Weil case in 1950, which was about infringement of the defence regulations. And for present purposes, the sentence I emphasise, would invite the board to emphasise, is the last one in paragraph 92, the way that case is described. The court could not, via a restitutionary claim, indirectly enforce what the regulations had forbidden. And then there's reference to further case law at paragraph 93, Diamond and Lovell, Wilson and First County Trust. And just below letter C, the way Lord Justice Aikens summarises the matter, or just at letter C, is, as your lordships will see, is this: to permit such a claim would be inconsistent with the intent of Parliament, which sets the public policy and the statutory provisions. As both Lord Nichols and Lord Hope of Craighead emphasised in the Wilson case, the question is, what did the statute intend? If it is clear that the statute intended that the creditor should not recover money advanced, then the court cannot attempt to override or outflank the statutory provision by substituting a common law remedy such as restitution. The application of that rule, which is undoubtedly a public policy rule, must depend on the construction of the relevant statutory provisions. And there's then reference to how that played out in the First County case. And there's then some reference to other authority and to textbook authority, and I just wanted also to pick up in this brief tour of the cases what Lord Justice Aikens says and what he quotes over the page, at electronic page 647, down at the end of end of paragraph 95. He's quoting what Professor Virgo wrote in the Principles of the Law of Restitution in 2006. A restitutionary claim in the case of a void contract should lie only when it is an appropriate way of fulfilling the policy which made the contract void in the first place. It may be particularly difficult to determine when such a restitutionary response is appropriate. You'll see that Professor Virgo's way of putting it is perhaps even more hostile to the notion of a restitutionary response. It's only when it's allowing the claim is itself a way of fulfilling the policy which made the contract void in the first place that the restitutionary remedy can be granted. Anyway, Lord Justice Aikens goes on to say that he draws two conclusions from the discussion. First, there's no longer any general rule of policy that prevents or restricts the right to claim restitution of money under a borrowing contract that's void as being ultra vires the borrower. Secondly, however, it is well established that if such a claim is inconsistent with the express provisions of a statute, or as I would say, its clear intention, then English law will not permit the claim as a matter of public policy. This is because a common law claim for restitution cannot be allowed to circumvent legislation whose object and effect is to bar such a recovery. And then there's reference to whether that's the same as change of position, to which the answer seems to be no, it's not, but we don't need to go into that, I think, for present purposes. That's Lord Justice Aikens in that case. There's also, if I may take the board to it briefly, a short passage from Lord Justice Etherton's judgment that I wanted to ask the board to look at. That's at page 665. Really putting the thing in the same principle in different words. Paragraph 150, about an inch or two down. As Lord Justice Aikens has pointed out, there is clear authority that a restitutionary claim for the return of money may be defeated where, on the correct interpretation of primary or secondary legislation, recovery and restitution would be contrary to the objective of the legislation. And Lord Justice Etherton goes on to say, those cases are best viewed, in my judgment, as examples of United Kingdom legislation which, on its correct interpretation, implicitly exclude any civil restitutionary remedy, whether for unjust enrichment or otherwise.
But what would be, you said in the opening the facts that some money was paid. Has the government claimed that money back as?
No, but it was money paid under a void contract, and the government could, in theory, claim it back, I would submit, but obviously that would be subject to all appropriate defences, and one would expect there might be a fairly vigorous change of position defence advanced by.
Well, how have they changed their position?
Well, because they've ordered well, it depends what they've done with the money, I suppose. But if they had, I mean, that would be for them to develop how the defence was to be made out. But they would presumably say that they'd taken the money and deployed it in good faith on the belief that they were entitled to it, and so the government shouldn't have it back. But that question doesn't, in my submission, answer the point. I mean, the fact that money changed hands before anyone noticed the point that actually there was no contract and that none of this should have been happening doesn't, in my submission, alter the analysis as to what the court should do when it is asked to require the government to pay more money, either pursuant to the contract, which it can't do because it's void, or by way of an alternative in unjust enrichment. Well, the next case I wanted to go to was Patel and Mirza. Patel and Mirza is, of course, an illegality case, and it's important, of course, to point out that we don't put this in terms quite of illegality. Illegality cases are, of course, concerned with circumstances where either the common law or a statute says essentially that you either shall not contract or you shall not perform the contract in the way in which the parties did perform the contract. We are concerned with, as it were, an anterior position that there shall be no contract. No contract comes into effect at all, simply because there's no authority on the part of the central tenders, on the part of the permanent secretary to contract. But nevertheless, there's an obvious similarity between the two areas, and that's why one sees reference to the stultification principle in the illegality cases, including Patel. And there's Patel's a very well-known case, and it would take hours to go through all of it, and I don't have time to do that. But by way of brief reference to it, may I just pick out a few relevant points for our purposes. Paragraph 115, which is at page 942, which is in Lord Toulson's judgment, is where the stultification approach is in that case endorsed. In the present case, I would endorse the approach and conclusion of Lady Justice Gloucester. She correctly asked herself whether the policy underlying the rule which made the contract between Mr. Patel and Mr. Mirza illegal would be stultified if Mr. Patel's claim in unjust enrichment were allowed. After examining the policy underlying the statutory provisions about insider dealing, she concluded there was no logical basis why considerations of public policy should require Mr. Patel to forfeit the monies which he paid into Mr. Mirza's account and which were never used for the purpose for which they were paid. Your Lordships will recall, of course, that was the case where he deposited some money in the other chap's account for the purpose of being used for illegal insider trading, and it never came to anything, so he said, "Can I have it back?" and was met with an illegality defence. She said that such a result would not be a just and proportionate response to the illegality. I agree. Mr. Patel is seeking to unwind the arrangement, not to profit from it. That may be, in our submission, is an important distinction in the present case, for reasons I'll come on to. Two other passages I just wanted to show the board, remind the board of.
Do you rely on that test, though, that it's not, whether it's a just and proportionate response?
No.
Is that another way of expressing the test, or a test that you rely on?
No, no. I mean, I read it out because I didn't want to give a misleading impression of what the paragraph said, but we don't submit that that's a consideration that ought to come into it. What's relevant in the present purposes is the stultification issue. Does it stultify the statute to allow the claim? Well, the other passages, just briefly, in Patel and Mirza that I invite the board to look at are, first of all, at page 964 in the dissenting judgment of Lord Mance, This is important because it highlights a distinction, highlights a respect in which it's rather easier in a Patel-type case for the court to say, well, notwithstanding the illegality, it's appropriate for the claimant to succeed. It's because what the claimant is seeking.
Which paragraph?
Paragraph 203, my Lord.
Thank you.
Follows that in the present case, said Lord Mance, I consider that no problem exists about recognising that Mr Patel is entitled to require Mr Mirza to return the stake which Mr Patel put up for the illegal purpose of use by Mr Mirza to make profits by misuse of inside information. The claim does not seek to enforce or profit by the illegality. It seeks merely to put the position back to where it should have been and would have been had no such illegal transaction ever been undertaken. And that same emphasis on the fact that that's all that's happening in that case, we can also see in Lord Sumption's dissenting judgment. Reference for that is page 979, end of paragraph 250. Middle of that paragraph, by letter F, restitution, the principle, as I've suggested above, is that the courts will not give effect to an illegal transaction or to a right derived from it. One has, of course, to caveat that heavily by pointing out that that's a dissenting judgment. But restitution does not do that. It merely recognises the ineffectiveness of the transaction and gives effect to the ordinary legal consequences of that state of affairs. The effect is to put the parties in the position in which they would have been if they had never entered into the illegal transaction, which in the eyes of the law is the position in which they should always have been in. Again, that's explaining why it's acceptable to require the repayment of the money.
But it might be said against you that all one's doing in relation to the quantum merit is exactly the same. You are just reversing the enrichment. Both parties have been put back into the position, so far as one can do it, when you've got work and services, and that there's no difference between that and the money situation. You're not enforcing a contract, you are reversing the enrichment, and therefore, in that sense, putting both parties back to where they were.
Well, my Lord, yes, of course that's right, and that, in a sense, that follows from the fact that we are dealing with an unjust enrichment claim. The difference in the present case, of course, is that one is not, in practice, simply compensating the claimant for an expectation that never materialised, or giving the claimant back something which it parted with, as in the money in the case of Mr. Patel. One is, in effect, putting the claimant in exactly the same position it would have been in if the Act didn't exist. Because
it depends on whether the contract price turns, or whether the jointly appointed independent assessor arrives at an amount which is the contract price, which we don't know whether they will or not.
Yes, I suppose the unspoken premise of what I've just said is that the contract price would have been a market price.
But that's the point, isn't it? That's what the Act is trying to ensure, that it is a market price, that it's not been inflated by some kickbacks, as the judge referred to.
That's one of the things, no doubt, that the Act is trying to ensure, but it's by no means the only thing that the Act is trying to ensure. The Act is trying to ensure that contracts are awarded pursuant to an entirely transparent process, which makes it impossible for ministers of whatever stripe to favour particular individuals who happen to be in business. And that doesn't, the corruption that the Act exists to prevent doesn't simply consist in the minister agreeing to an inflated price. It consists in the minister agreeing to appoint person A rather than person B, because the minister has personal connections with person A that he or she doesn't have with person B. So that's by no means a complete answer, in my respectful submission.
But it is an important policy behind a tendering process that one is trying to get good value for money.
Yes.
And as I understand what you've just said, well, a restitutionary claim would not infringe that policy, because by definition you're giving the objective market value. So you're left with having to rely, are you not, on another purpose which you say is the corruption purpose.
Yes, which is, I can't deny the fact that a restitutionary claim, by virtue of the fact that it gives the market value of the services provided, doesn't leave the claimant better off than the claimant would have been if the Act had been followed. Because presumably if the Act had been followed, the board would have seen to it that the price that was going to be paid was a market price. And in a building contract, that would be, certainly as regards variations, inevitable, because that's how the quantum meruit, the contractual quantum meruit, would have been worked out. But that, as I say, that's really only part of the reason for the Act.
But if another part of the reason was to prevent sort of cronyism, as you referred to it, of appointing an incompetent person to do the work, then that would also be reflected in a disparity between the quantum meruit for a market value assessment of what may be shoddy work, which would be below the contract price agreed.
Well, your ladyship introduces another factor into the discussion, which is the idea of shoddy work and
yes. What we're trying to identify is why, giving the market value for the work done, contravenes the policy of the Act, and the policy of the Act is described as preventing kickbacks, preventing cronyism. What I'm pressing you on slightly is, doesn't reducing the amount that the claimant gets to a quantum meruit rather than the contract price meet those two purposes? I accept you say there's another purpose of transparency, but is that the purpose that you rely on as saying that they shouldn't even be entitled to a quantum meruit, or is there some other purpose?
Yeah, I say they shouldn't be entitled even to a quantum meruit because to give them a quantum meruit, give the claimant a quantum meruit, stultifies the purpose of the Act. It gives the claimant exactly the same thing that the claimant would have got if the Act didn't exist. Now, it may be true, of course. There might be some other claimant who comes along and says, "I had this fantastic contract with the government where I was being paid twice market rate,
Yeah.
and I wanted."
It may or may not give exactly the same thing, because there can be good contracts and bad contracts, even if they've gone through the board.
Yes.
But I think your main point is that it just ultimately undermines the fair and transparency objective of ensuring that work for government is properly competed for in a transparent marketplace,
yes,
where everyone has an opportunity to bid.
Yes, and that essentially, my lord, is the point, and the fact that the court's adopting a quantum meruit approach prevents a claimant who has circumvented the Act from getting more than the market value is, I suppose, one thing to be said in favour of quantum meruit, and it could be worse if the claimant, and obviously if the court, if the claimant was saying, I had this contract with the government for this fantastically high price, which and on analysis it turned out to be not a market price, but I nevertheless want to enforce it because why shouldn't I? I did it in good faith, and that's what I want, and that's what I'm entitled to. Then obviously the court, that would be an easy case for the court to the extent that it was knocking the claimant down to the level of a quantum meruit. The question is, what about the hard case, which we're faced with? And our submission, as you will have gathered, is that in this case the court allowed itself to make bad law in the face of this hard case, because it said that the market price could be obtained. But that doesn't by any means address the full the mischief that is sought to be confronted by the Act. So, Lord, I better pick up the pace a bit, because I see the time. I promised to try to get through it in less than the agreed time is falling apart in front of me. 981, my Lord, is the other passage in Patel and Mirza I wanted to take the board to, again in Lord Sumption's judgment. I say nothing about cases in which an order for restitution would be functionally indistinguishable from an order for enforcement, as in a case of an illegal loan or foreign exchange transaction. Or, I would respectfully add, as in the present case. The traditional view is that if the law will not enforce an agreement, it will not give the same financial relief under a different label. Boissevan and Weil is cited. I'm inclined to think that the principle is sound, but I should prefer not to express a concluded view on the point. It is not the position here. So, Lord, that's Patel. The other case I wanted to take the board to briefly is the Singapore case of Ochroid Trading, which considered Patel. In fact, declined to follow Patel, but what's interesting for present purposes is not that, but what it says about stultification. Ochroid Trading, which starts at page 762 in the bundle, and it's a long judgment which I can only just ask the board for present purposes to dip into, but it's a case about, as some of your lordships already know, it's a case about money lending legislation being contravened in the course of private parties' arrangements, whether that meant that the one party couldn't get the money back, essentially, from the other. And perhaps I can ask the board to pick it up at page 830, pick it up at 833. This is where the Court of Appeal of Singapore is discussing illegalities of defence on the public policy aspect of illegality. Para 145, they discuss some other approaches that were taken in Patel.
Which of the Singapore Court of Appeal judges is speaking, or is this the judgment of the court?
I think it's the judgment of the court.
Okay, thank you.
Albeit delivered by Justice of Appeal Andrew Fang Boon. Para 145, they've said that neither of the two ways in which the courts of the United Kingdom have put things is satisfactory. But they go on to say, instead, taking reference to the seminal article by Professor Birks, we endorse the principle of stultification, which would preclude allowing a claim in unjust enrichment if to do so would undermine the fundamental policy that rendered the underlying contract void and unenforceable in the first place. And they go on to explain why they've got to that and why they rejected various other alternative approaches. And then perhaps I can just invite the board to pick it up.
Do you agree with that summary of stultification?
I'm sorry, my lord?
Do you agree with that summary of...
Essentially, yes, we essentially adopt that summary of the principle. I mean, whether that precisely maps on to Patel and Mirza may be a different question. Perhaps it doesn't, because they say the approach in Patel and Mirza wasn't quite right, but it certainly maps on to Haugesund, which is in the specific case of what if a contract is just void. And they go on at the top of page 834 to talk about the concept of stultification, and they quote what the late Professor Birks had said in his article. Bottom of that page, bottom of 834, they say, they hasten to add, they've added the word fundamental, because there could conceivably be situations where to permit recovery pursuant to a claim in unjust enrichment might appear to the court to undermine some other policy, which policy, however, was not central to the prohibition of the contract concerned. Much, therefore, will depend on the precise policy considerations as construed in their context. They then take a little canter through some of the authorities around the world. And then at paragraph 158 on page 839, the Learned Justice of Appeal says, deals with the argument that restitutionary recovery should generally be allowed because it simply places the parties back in the position they would have been in if the illegal transaction had not been entered into. They refer to Goff and Jones, and the Goff and Jones's comment, which they call perceptive, as your lordships will see, that while the majority appeared to be of the view that claims in unjust enrichment create less risk of stultification than claims to enforce an illegal contract, matters are not so simple, and there is more room for argument than the Supreme Court acknowledged in Patel over the question whether awarding restitution will stultify the purposes of a rule making the contract illegal. We entirely agree, as Professor Birks noted, even where the restitutionary claim does not give the plaintiff substantially the same performance as he would have had under the illegal contract, which he termed the identical yield argument, there is still the danger that the alternative claim may stultify the position taken by the law in relation to the illegal contract.
I'm so sorry, I've lost the paragraph you're in.
Sorry, I'm at page one, para 158, middle of
Thank you.
158.
Yeah.
And they quote what Professor Birks had said about the mere case, as I would put it, of getting money back or getting property back. It's likely to do one or both of two things: provide a lever which this and the class of all similar plaintiffs can use for the purpose of getting the other to perform the contract, and B, stretch out a safety net below all those minded either to engage in similar illegality or to abstain from diligently inquiring whether their proposed course of conduct does or does not run foul of it. Just for completeness and briefly, my lord, the result in that case was that the illegality defence succeeded. That was because the alternative claim, it was held, would undermine and stultify the social and public policy against unlicensed money lending. That's paragraph 219, page 875. We made brief reference in our printed case, and I'll just take your lordship to it very briefly, to the American Law Institute restatement. That's at page 1347. Again, it's in the context of illegality, which is not quite the same thing, but has obvious similarities. Restitution will be allowed, as paragraph 1, under section 32, subparagraph 1. Restitution will be allowed whether or not necessary to prevent unjust enrichment if restitution is required by the policy of the underlying prohibition. We're not in that territory. 2, restitution will also be allowed as necessary to prevent unjust enrichments if the allowance of restitution will not defeat or frustrate the policy of the underlying prohibition. And that's the relevant point for our purposes. Will it defeat or frustrate the policy of the underlying prohibition?
But
So,
it's important there, restitution will be denied if the claim is foreclosed by the claimant's inequitable conduct. So do you accept here that it's important that the finding of fact was that the claimant here did not know that the contract ought to have gone through the board? So it would not, granting a remedy here would not stultify the policy in the sense that if there was evidence that this was a collusive arrangement between a construction company and a minister.
Yes. Well, I think all I would say about that, my lady, is that clearly the case would be much easier, from my point of view, if there were. If there'd been a finding of fact that the claimant knew perfectly well that it was infringing the Central Tenders Board Act, but decided it didn't really care about that, then obviously it would be easier to say, well, I mean, one would feel more comfortable about saying, well, tough luck, you don't get paid. But the fact that I don't have that additional line of defence doesn't tell us anything in my submission about the right answer to the question. So against that background...
Sorry, are there findings of fact in relation to that, about the knowledge of the contractor?
I don't think that there are specific
Or maybe it was...
findings of fact, but it's certainly common ground. That,
yes, sorry. Maybe a better way of...
I mean, I put it negatively. It's no part of the appellant's case to say that the claimant knew.
I thought the judge at first instance said that the claim was, at least said that the claim was proceeding on that basis, but I may be mistaken.
Well, don't worry, Mr.
No, I can't recall the present clock.
You're up against the
I am a little up against the clock, and I've got six reasons why the court's bill was wrong to get through in about 25 minutes. So let me take them briefly. My first reason is one I can take very quickly because I've effectively already flagged it up in the course of what I've already said. That is to say that the Court of Appeal was wrong, respectfully, we submit, to say that the Act was simply concerned with administrative convenience. That's well wide of the mark. It's a constitutional statute, essentially, that is of great importance, and that reason alone requires the reasoning of the Court of Appeal simply to be set aside and the decision to be reconsidered, even if we were doing the sort of case where that was the test. It doesn't matter for present purposes because the question is one of law. The second point is that we submit that the Court of Appeal were wrong to place weight on the omission in the Act to provide specifically that legal and equitable rights arising out of any contract which was out with its provisions were unenforceable. I should say, my Lord, I'm following the scheme of our written case, so if that enables your note-taking to be a little bit briefer, we're on page 435 and following of the printed case. And all I say about that is, of course I accept the Act doesn't spell out, and for the avoidance of doubt, the consequence of all of the above is that if both parties ignore the Act and behave as if it didn't exist, whether knowingly or unknowingly, the court shall not allow a remedy in restitution. I accept the Act doesn't say that, but that's a common state of affairs in many cases involving illegality. We give one example, a perfectly rather banal example in the written case of the Road Traffic Act 1960 that talks about it being an offence to transport certain sorts of goods on certain sorts of vehicles. What happens if there's a contract to transport goods on the wrong sort of vehicle? It's not relevant. It didn't occur to anybody in that case to say, well, the Road Traffic Act doesn't say that a contract to infringe this provision is unlawful. So that's simply not a point in our respectful submission that assists the respondent at all. The third criticism we make is the weight that was placed by the Court of Appeal on the case of Water and Sewerage Authority and Sukhanand Singh. We can see that paragraphs 25 and 26 of the judgment in the Court of Appeal, which you can find at page 194, I think. I'm fortified in my view by the dictum of Chief Justice de la Bastide in that case. The short point about that is that was a completely different case, because that was a case where the Central Tenders Board had given an assurance that there was a binding contractual relationship between the claimant and the government.
So that was an administrative case, in a sense.
Yes. Yeah, and the reference is page 1247 in the record. I'm not prepared, about halfway down, I'm not prepared to accept that the failure to enter into a formal contract, which one would normally expect to be initiated by the statutory authority, would serve to defeat the contractual rights of a party who, as in this case, has been assured by the Central Tenders Board that it has succeeded in establishing a binding contractual nexus. So that's got nothing to do with the present case at all. In our submission, fourthly, we submit respectfully that Justice of Appeal Burrow placed too much weight on the need not to punish the claimant, as his lordship put it, and on the need to do justice between the parties. And I take that from the section I think we've already looked at, paragraphs 23, 24, and so on, in the judgment. Paragraph 29, which to some extent I think does answer your Lordship's questions earlier about what exactly was found. The same, this is page 197, the same must apply here. That's a reference to an earlier case. No suggestion the claimant was aware of the Permanent Secretary's lack of authority or some other element of collusion on its part to circumvent the provisions of the Act. The respondent was not seeking to go behind the Act's provision. The respondent was not deliberately seeking to circumvent the provisions of the Act. It should not be punished except by clear statutory provision for the Permanent Secretary's error. My Lord, our short, perhaps forensically unattractive, but nevertheless, in my submission, correct point about that is that one is not, in these cases, the court is not in these cases to be overly concerned with whether the effect of what it does is to punish a claimant. The court is not, of course, acting so as to punish a claimant. The court is simply giving effect to the nature of the public policy bar. And it's notorious, of course, that it's part of the consequences sometimes of, in the illegality context, of the principle that you can't, in certain circumstances, enforce an illegal contract, that it operates harshly in particular cases. And this is obviously a hard case. But that's not, in my submission, a reason for not applying the plain rule. And there is a counterpoint as well to that, which is that although, of course, it's true in the present case that the claimant did not deliberately seek to circumvent the Act, and it was unaware of the Act is scarcely an obscure provision that is tucked away somewhere in a departmental circular that you could get by going through the paper records of the Gazette. It's an Act of Parliament. And the point was put well, in our respectful submission, in a US case that we cite in our case. You can find the relevant passage at page 610. It's in the right-hand column on page 610. It's a decision of the Supreme Court in New York. Towards the bottom of the right-hand paragraph, although it may seem that was a case, I should say, where there had been no prior appropriation of the relevant funds by the relevant public body. So the public body wasn't authorized to enter into the contract at all. It may seem harsh to deny plaintiff payment for services rendered at the request of the municipal officials. Plaintiff, although it may seem harsh, plaintiff, in the absence of an appropriation, undertook the work at its own risk. It has often been repeated that since the powers of a municipal corporation are wholly statutory, every person who deals with such a body is bound to know the extent of its authority and the limitation on its powers. Now, that's, of course, New York law, and your lordships are not obliged to take the same view, but there is, in my submission, some force in that point. Here is a statute which makes quite clear what's meant to happen. We're not concerned here with some minor infringement of the minor infringement of the regime, or failure to follow the regime by a party that perhaps could be forgiven for not understanding it. This is a major contractor doing major work for a significant amount of public money. And although undoubtedly it may seem harsh, there is, in my submission, some force in the point that the statute has to be given effect. Our fifth criticism of the Court of Appeal's reasoning, and our fifth submission really as to why the appeal should succeed, is that the Court of Appeal's reasoning, we respectfully submit, overlooks the key factor, which is that allowing the claim, and therefore by implication allowing any other claim that arises on the same sort of facts, does undermine the effectiveness of the regime established by the Act. And that's a point that I've already developed to some extent, and perhaps there's not a great deal more that I can usefully say about it. But it simply is, in my submission, impossible to deny that the effect of granting the claimant what the claimant seeks in the present case is to put the claimant in exactly the same position as if the Act had never applied. And in an earlier case, which I'll come to in a minute, the House of Lords said the effect of that is for the court to repeal the statute. One doesn't necessarily need to put it in quite such stark terms, but that essentially is what the granting of this restitution remedy will do. And we respectfully adopt...
that assumes that you've completed the work.
Sorry, well, that assumes...
That assumes that you've completed the work. I mean, you might say that the contractor has taken a huge risk, because at every point at which they are starting to perform, they've got no contractual entitlement.
Yes.
So it's not exactly as if this is going to encourage people to subvert the tendering process because they're taking a huge risk in doing so, are they not?
Well, they're taking...
I mean, the way you're putting it is, oh, it's fine, you just get exactly what you get under the contract, but of course that assumes that you've actually completed work that is going to be accepted and so on and so forth. You've got no right at any point to sue the other party in relation to contractual enforcement.
No, but if the board dismisses the appeal, you've got a right on the authority of the Court of Appeal to a quantum merit in respect of all the work that you've done.
Yeah.
Now, I agree, of course, that a well-informed tenderer wouldn't say, well, let's not, don't worry, see Attorney General v. Trinsalvage, we don't need to worry about getting a contract. I mean, pretty negligent of their legal team if that's the advice they gave.
What happens to subcontracts that the construction company has entered into with scaffolders or digger lenders? What happens to those?
Well, those contracts aren't required to be dealt with by the board. That's a matter between the respondent and those subcontractors. They'd be liable under the board, probably. Yeah.
Well, I think you're up against your...
I'm up against my...
That's one more point.
I think I've got 15 minutes.
Oh, I'm so sorry.
I think. Is that right? Yes, I'm looking at the wrong thing. 11:45.
Oh, you're quite right. I'm sorry.
Not quite as short a time as your lordship must have thought I was, but you thought I was going in a very relaxed fashion on that basis. So that's as I say, that's our fifth point, that we respectfully submit that the decisions below simply don't face up to the fact that permitting claimants to recover the value of unauthorised work does undermine the effectiveness of the regime established by the Act. The sixth point we make is that the court below does not appear to have taken account of, and our learned friends' submissions don't take account of, the fact that here, unlike a person who is seeking merely to get back, like Mr. Patel, the money that has been spent or handed over, or property handed over for some nefarious purpose, or in circumstances where there's no contractual right to get it back, what in practice happens here is that the claimant is put in the same position as if there had been a contract, or as if a proper contract, or as if the Act hadn't existed. And I know I've already made that point a few times, so I don't want to labour it. But as there's a convenient label for it in Professor Birks's writings, which we've set out in our case. It's the identical yield argument. And that's why I emphasised earlier, Lord Sumption had said about the traditional view being that if the law won't enforce an agreement, it will not give the same financial relief under a different legal label. And we quote in our case also what Lord Bingham said in Mohammed and Alaga. Perhaps there isn't time to go through that case now, but it's in our case at page 440. If recovery under the contract was precluded on grounds of public policy, the plaintiff could scarcely hope to recover exactly the same relief by relabelling his ground of claim. Although it's, in the interest of full disclosure, it's fair to note that in Mohammed and Alaga, the claimant did succeed to some extent. Very briefly, that was the claim where the translator entered into an agreement with the solicitor that he would take a cut, I think, of what the solicitor got from the Legal Aid Board, which was plainly unlawful. And at first instance, the claim failed. On appeal, the claim succeeded to the limited extent that he did get a quantum merit for the actual value of the work. And one of the relevant factors there was that he was not seeking what he was entitled to under the contract. But we respectfully say in our case, query whether even that was right. And it's fair to say that case is described by Professor Birks was described by Professor Birks in the article that was cited by the Singapore Court of Appeal, which incidentally you can find at 1372. It was described as a surprising outcome. On the other hand, finally, under the head of full and frank disclosure, I think the Supreme Court in Patel said it was to be regarded as rightly decided. But it's a rather different sort of animal, because it's concerned with whether in that case something could be obtained for a claimant who did at least have a basis, or would have had anyway, would have had a basis for claiming from the solicitor The difference in the present case, of course, is that there is no basis for claiming from the government, because the only, other than the restitutionary claim, because it's not a case of a contract entered into by the government where the government slips up on some formality. It's a case where actually the government, looking at it through the proper constitutional lens, as it were, looking at it through the Act, the government itself never asked for any of this work to be done. Ministers saw that the work was being done and did nothing to stop it. Ministers encouraged it, or the permanent secretary encouraged it, but through the eyes of the Act, the only party entitled to say anything on behalf of the government was the board, and the board said nothing. My Lord, our final ground for seeking to uphold the decisions below is that we respectfully submit it would actually be inconsistent with a decision of the House of Lords, and that's the decision of Young against Mayor and Corporation of Leamington Spa, Royal Leamington Spa, forgive me. That was a case that was looked at by the Court of Appeal in the present case, but it was said, well, it's an old case and things have moved on since then. But in our respectful submission, it's not only right, it's actually, if one looks at it closely, we respectfully submit indistinguishable, and therefore, in substance, what my learned friends are asking your lordships to do is to depart from it. May I take the board to that case? It's at page 1333. And it concerns section 174 of the Public Health Act 1875, which said that every contract made by an urban authority whereof the value or amount exceeds £50 shall be in writing and sealed with the common seal of such authority. And the facts, which are as simple as the facts in the present case, were simply that the corporation purported to contract with the plaintiff for the completion of some building works, neglected to do so under seal. Plaintiff didn't notice the error or the significance of the error, if it did the works. As far as we can see, everybody in Leamington Spa was satisfied with the works, and they benefited the citizens of Leamington Spa. They were paid some sums by the corporation, but left a balance of £6,000 to £7,000, which is about between £500,000 and £600,000 in today's money, which the corporation refused to pay, and so the building contractors sued. So it's a rather similar, it has a rather strikingly similar case to our own. Except in one respect, where I respectfully submit this present case is even more striking, which is that this was a case where the corporation did intend to enter into a contract. All the corporation did was that it failed to ensure the contract was under seal. Contrast the present case where the government, in the broader sense of the executive, did not intend to enter into the contract. What happened was that the permanent secretary, who was not the person authorised to say anything on behalf of the government about this, purported to enter into a contract. The organ of government, if I can put it that way, that was charged with deciding whether to enter into contracts, never did anything, namely the Central Tenants Board. Anyway, how did the courts in the...
Do we get any statement of what the statutory purpose of requiring a seal was in Young?
Yes, we do. I'll come on to it in just a second. We do. Again, rather as in our case, a lot of the decision is concerned with not how can this be got round by restitution or whatever, but with what is the effect of the absence of a seal. So we don't need to look at that, because ultimately the answer is that it was fatal to the contractual claim. Lord Blackburn gave the first judgment. That starts at page 1335. We don't have the report of the decision in the Court of Appeal, but it's quoted at length in the judgment. And at the bottom of 1337, we see Lord Blackburn quoting Lord Justice Lindley. The last point urged for the plaintiffs was that as the contract has been performed and the defendants have the benefit of the plaintiff's work, labour and material, the defendants are at all events liable to pay for these at a fair price. In support of this contention, cases were cited to show that the corporations are liable at common law quasi ex contractu to pay for the work ordered by their agents and done under their authority, which, I say this tentatively in present company, but I think I'm right in saying that's in at least a loose summary, that's a 19th century way of saying liable in restitution or in unjust enrichment, to pay for work ordered by their agents and done under their authority. The cases on the subject are very numerous and conflicting and will require review and authoritative exposition by a court of appeal. That's to say the cases about exactly when unjust enrichment, in modern terms, works and doesn't work. But in my opinion, the question thus raised does not require decision in the present case. We have here to construe and apply an Act of Parliament. The Act draws a line between contracts for more than £50 and contracts for £50 and under. Contracts for not more than £50 need not be sealed and can be enforced whether executed or not, etc., without reference to the question whether they could be enforced at common law by reason of their trivial nature. Contracts for more than £50 are positively required to be under seal, and in a case like that before us, if we were to hold the defendants liable to pay for what had been done under the Act, we should in effect be repealing the Act of Parliament and depriving the ratepayers of that protection which Parliament intended to secure for them. And then some authority for that further authority is quoted. And it's said at the end, it may be said that this is a hard and narrow view of the law, but my answer is that Parliament has thought expedient to require this view to be taken, and it is not for this or any other court to decline to give effect to a clearly expressed statute because it may lead to apparent hardship. For these reasons, I'm of the opinion that the decision of the court below was correct and the appeal ought to be dismissed with costs. And Lord Justice Cotton concurred in that judgment. Lord Justice Brett, in the Court of Appeal, came to the same conclusion, said very frankly he'd come to the same conclusion after weeks spent in attempting to come to another conclusion. He explains, first of all, why he dismisses the contractual claim, and then, towards the end of the first substantive paragraph, further, after having read all the cases with regard to the doctrine of work done for and accepted by a corporation, I am bound to say that I have come to the conclusion that even if this were a municipal corporation not bound by the statute, the proper decision in point of law, according to the cases in principle, is that the want of a seal prevents, in such cases as this, the plaintiff succeeding. That's the Court of Appeal. It's fair to say that I don't think anywhere Lord Blackburn positively says I agree with that, but by necessary implication that must be what is done. The rest of Lord Blackburn's speech, as I should call it properly, deals really is focused on the question of whether you can say essentially that the absence of a seal is not fatal to the contractual claim. He doesn't in terms go on to address the claim quasi ex contractu. But by necessary implication, he must be endorsing the large passage he just quoted from Lord Justice Lindley and Lord Justice Brett. And then at 1343, Lord Blackburn says, it's true that this works great hardship upon the now appellants. They had an agreement, but it was not sealed. And though it is possible that if the agreement had been under seal, the defendants might have established a defence on the merits to all or part of what is claimed, it is hard on the appellants that they should not be allowed to raise the question. It is, however, for the legislature to determine whether the benefits derived by enforcing a general rule are or are not too dearly purchased by occasional hardships. A court of law has only to inquire what has the legislature thought fit to enact. And he therefore says the appeal should be dismissed, which is to say that the plaintiff gets nothing, and Lord Watson concurred in that judgment. And Lord Bramwell gave a speech agreeing that the judgment below should be affirmed, again agreeing that the Act was obligatory and not just directory, so there was no contract. He says, and in a sense I've already, I think, because I should add that the last judge to speak, Lord Fitzgerald, also agreed with Lord Blackburn, so I've got a majority of the court already on the basis of Lord Blackburn, Lord Watson and Lord Fitzgerald. But Lord Bramwell, as I say, agrees on the question of the contractual argument, doesn't, it's fair to say, expressly address the quasi-contract argument, although he says, as I think the case turns on the construction of the statute, I have not thought it necessary to go into the doubtful and conflicting cases governed by the common law. But he then says, as your Lordship say, we'll see this in remarkably stringent terms. I must add that I do not agree in the regret expressed at having to come to this conclusion. The legislature has made provisions for the protection of ratepayers, shareholders and others who must act through the agency of a representative body, by requiring the observance of certain solemnities and formalities which involve deliberation and reflection. That is the importance of the seal. It is idle to say there is no magic in a wafer. It continually happens that carelessness and indifference on the one side and the greed of gain on the other cause a disregard of these safeguards, and improvident engagements are entered into. Whether that has been so in this case, I have no notion, but certainly the ratepayers of Leamington may well be astonished at the amount claimed of them. The decision may be hard in this case on the plaintiffs, who may not have known the law. They and others must be taught it, which can only be done by its enforcement. So that's Lord Bramwell, and as I say, Lord Fitzgerald agrees with all of the other members of the court. My Lord, my respectful submission about that case, as I say, is twofold. One, I say it points the way to the correct answer in the present case. Hard though it is, the statute must be upheld, and the effect of granting a claim in unjust enrichment is to allow the statute to be circumvented, and that is contrary to public policy, and would effectively amount to the board repealing the Act, to use the terminology used in Young & Co. And my second submission about that is that the case is effectively indistinguishable, and therefore the board ought to follow it unless there is some good reason positively to depart from it. It's true, of course, to say that it's an old case. It's true, of course, to say that the law of unjust enrichment has moved on since then. But that's not really that's not a material difference in my respectful submission.
Well, you might say it's a formality case, and that formality is now gone, if one was seeking to distinguish it.
Well, there certainly is a point of distinction, which is that it's a formality case, whereas our case is not a formality case. But I would respect it, but our case is an a fortiori case, because our case is not merely a formality. It's not that the government was entitled to contract with the appellant, with the respondent rather, in the present case, but omitted some formality in doing so. In the present case, the people who purported to contract were not entitled to contract at all.
But isn't it distinguishable on the basis that they're dealing with a different act, and they have said, well, we don't have to worry about all that complicated law about what we would now call unjust enrichment, because we're just construing the act, and construing that act and thinking why the seal was required. They say that policy would be stultified, but you have accepted that the test we have to apply is the policy of the act we are looking at stultified by the grant of the remedy. And well, if that's the test, I don't see how you can say that this case, which is about a completely different act, is indistinguishable.
Obviously the premise of my submission that it's indistinguishable is that the policy in the Young case was essentially, was relevantly for present purposes, the same policy. Exactly the same policy considerations were apparent in the Act that was under scrutiny in the Young case as are apparent in the present case. All about, and indeed, in my respectful submission, the present case is a clearer case than the Young case, because one might have made the contrary argument in Young that it was merely about a seal.
Do we get any more on the policy of this old Act than that having to do something under seal requires or is likely to involve deliberation and reflection? I'm looking at that bit on page 1344.
I think that's the only part of the Act of the decision in Young that.
You get pause for thought before you execute a deed.
Yes. Yeah. Well, ours is. I mean, that's why I say ours is rather an a fortiori case. Well, I mean, it might be.
I'm just asking whether you get anything else from this judgment about the policy of the Act requiring it to be under seal. I mean, the trouble is that doing things under seal is probably a greatly watered down process now than it was in the mid-19th century when this was decided. So it's quite difficult for us to get our minds back without being historians to why a seal matters so much.
Yes, I suppose that's right, but presumably one doesn't. I mean, the detail of it, no doubt, is a matter for legal historians, but presumably the point is that you've got to go and get whoever's in charge of the seal and get them to come along, and necessarily that flags up to other members of the authority what's going on. Of course, in in the present case, of course, there's a great deal more that needs to be done, and it's in a sense, I say, our case is a much stronger case than Young.
I understand that. Well, I think you really have gone over your...
I really have. I will. I think in the usual fashion, I'll have to give back 4 minutes of my reply time. But unless, my lord, there are further matters that I can conveniently address now.
No, thank you very much.
That's what I want to say.
We'll rise until 5:02. Yes, Mr. Mark.
Much obliged, my lord and my lady. I would like to start with submitting that the Court of Appeal was correct and applied the correct legal principles in holding that the Central Tenders Board Act would not have been stultified if there was a claim for unjust enrichment awarded in favor of the respondent. My learned friend, Mr. Rowe, has in many ways, in effect, submitted that as a defense to this claim for enrichment, unjust enrichment, that the Act prohibited the contract which was entered into in this case, and therefore he's in effect raising the defense of illegality. As I understand the law, with the greatest respect to my learned friend, is that where that issue is raised, it has to be shown that the statute, in this case the Central Tenders Board Act, either expressly or impliedly prohibited the statute. I'm sorry, prohibited the contract. And then if it is found, or he cannot establish, that the statute expressly or impliedly prohibited the contract, then the common law principles of illegality apply. And therefore, it is important for the board to see how the Court of Appeal dealt with this issue, bearing in mind that at the time the High Court dealt with this matter, Patel and Mercer was not yet decided. And at the time the Court of Appeal dealt with this matter, the judgment of Lord Justice Underhill in Okadina was not yet decided. The way the case proceeded in the courts below, if I can take the board to electronic bundle 3, page 3, the statement of claim. And just briefly, I would point out that the claim was based on the fact that there was a process of tendering that went through the government.
Sorry, which page are you on?
I'm sorry, page 6. I do apologize.
Page 6.
Page 6.
Thank you. Yeah.
And the board would see that at paragraph 4, there was a process that started. There were tenders. There was a bill of quantities. And paragraph 12, there was a bill of quantities. And there was a process which would normally have been followed if a contract was being awarded by the state. The only difference was that the permanent secretary was acting ultra vires. Then, if one goes to the defense on page 10, one would see that the only defense was, at paragraph 2, that the permanent secretary and the young partners did not have the authority to enter into the alleged contract. And then, so that but in fairness to when one looks at the consent application on page 14, electronic bundle 14, one, and my learned friend referred the board to that at page 15, Roman numeral 2, in relation to the issue of quantum, the parties have agreed to appoint a joint independent expert to determine or ascertain the value of the works. So the claim for unjust enrichment, quantum merit, was based not on damages, to obtain damages, but to get the value of the works. In other words, to get the value of the enrichment by the state.
So that is the reasonable price for the work?
Yes, yes, ma'am. I just want to correct the record. As far as I understand from the junior who appeared in the matter below, there was no cross appeal by the respondent in this matter. My lords and my lady, my friend made some submissions, and before I go into the Court of Appeal judgment, he made some submissions in relation to whether in a restitution claim, the award should not resemble a claim for damages and etc. It should be a restitution claim. Lord Newberger, in the case of Patel and Mirza, EB 171, I'm sorry, at EB 956 at paragraph 171, stated, thirdly, it may be said that application of the rule would result in the court sometimes getting precious close to enforcing an illegal contract, a course which the court most certainly cannot take, as already mentioned. I accept that application of the rule would sometimes involve the court making an order whose effect in practice is similar to performance of the illegal contract. But there is nothing in that point. If a particular outcome is correct, then the mere fact that the same outcome could have been arrived at on a wrong basis does not make it wrong. It does not make it the wrong outcome. Indeed, it is worth noting that the outcome in Tribe and Tribe was precisely what it would have been if the contract in question had been enforced. The father had transferred the shares on the basis that it would help him avoid a threatened claim, and they would be transferred back when the claim was no longer threatened. He sought an order for the transfer after the threat had gone away, and application of the rule resulted in that order. So, in my respectful submission, if there is a claim of unjust enrichment and the order is to get the value of the works, it's really not to get or to try and make a profit of what occurred. It's purely to be put in a position as the claimant would have been if that contract did not, was not performed. I think when one looks at the decision of the Court of Appeal, and that decision which affirmed the order of the High Court, and I take the board to electronic bundle page 174. The Court of Appeal and I'll take it from after what the court will be said in the case of Young, at paragraph 16, page 187. I'm sorry, at paragraph 17, page 188. The court referred to the decision in Patel and Mercer, and then the court referred at paragraph 20 to the decision of Oxenden Commune, I hope I pronounce it correctly, and which it stated that the English Court of Appeal held that a lender under a borrowing contract which was void because it was ultra-virus could recover the sum lent in a restitutionary claim in law, but that any such claim, of course, subject were appropriate to any available restitutional defenses, including any that could legitimately be based on public policy. In coming to the decision that the restitutionary claim was not barred, the Court of Appeal held that the English court should take into account the express or implied intention of the foreign statute, etc., etc. And then the Court of Appeal referred to a decision of the Trinidad Court of Appeal in the matter of Ramhit. And in that decision, we would see at page 193, at paragraph 22, Justice of Appeal Barrow, who gave the unanimous decision of the Court of Appeal, stated that case was concerned with whether a contract with a wholly state-owned limited liability company could bind the state, which is totally different to our case. But important, at the end of that paragraph, stated at paragraph 12, Rajkumar J. noted that the issue was not ventilated by the trial before the trial judge, but may be subject of further consideration. Indeed, the unjust enrichment issue was not ventilated in that case. But you would see later down, when the court looked at two cases to consider the policy of the Central Tenders Board Act, what the court held. At paragraph 23, which my learned friend read to you, the Act establishes the board, etc., and referred to the two cases, Suknanan and Ramhit, another Ramhit. When we go to Suknanan, if I take the board to page 195, after the then Chief Justice dealt with Section 26(1) of the Central Tenders Board Act, His Lordship stated, the issue in Suknanan Singh was different, of course. The contract was awarded by the Central Tenders Board, and there was no doubt that the Central Tenders Board intended to contract with the claimant. But the dictum of the Labasid CJ supports the view that any prohibition against the enforceability of the informal contract should be, as a matter of policy, clearly spelled out in the Act. And that would be an important principle when we come to how the law has developed in determining statutory illegality as a defense to a claim for unjustment enrichment. In my judgment, the same applies to the case at bar. If it were intended to prohibit the enforcement of rights other than through a contract issued under the authority of the Central Tenders Board, it surely, as a matter of policy, would have been expressly set out in the Act. Further, not only has the state benefited from the works, but all monies due on the principal have been paid in full, although the contract was unenforceable. Indeed, the full facts of this case have surely not been revealed. It is more than a little odd that no objection was taken to the payment of the principal, which was comfortably over the statutory limit of the PS authority, but such strong objection to the variation course has been taken. The approach of the Labasi CJ in Suknanan Singh is consistent with the modern approach. Then the court went to the Ramit case, which was decided in 1966. 1996. And it's important what the Court of Appeal said in respect of the Central Tenders Board Act. And there's a mistake with the name ordinance, but the Central Tenders Board Act. The provision of work and services to the government is not expressly or impliedly prohibited by the ordinance. In the present case, the ordinance prescribed the penalties for illegal performance on the part of government and public officers only. When the policy of the act in question is to protect the general public or a class of persons by requiring that a contract shall be accompanied by certain formalities or conditions, and a penalty is imposed on the person omitting those formalities or conditions, the contract and its performance without those formalities or conditions is illegal and cannot be sued upon by the person liable to the penalties. But the other party to the contract is not deprived of its civil remedies because of the criminal default of the guilty party, see treaty on contracts, etc. Where a government agent breaches the ordinance in the absence of knowledge or collusion, the other contracting party is entitled to avail itself of its civil remedies. The respondent is therefore entitled to recover the sums claimed. Then at paragraph 29, which the court dealt with the policy, the same must apply here. There is no suggestion that the claimant was aware of the PS lack of authority, or that there was otherwise some element of collusion on its part, such as to circumvent the provisions of the Act. The respondent was not seeking to go behind the Act's provision. It is simply that the PS, as a matter of fact, lacked the authority which on the face of it he appeared to have. The respondent was not deliberately seeking to circumvent the provisions of the Act. It should not be punished except by clear statutory provision for the PS's error. Indeed, it would have been an entirely different matter if it had been shown that the respondent was well aware of the PS lack of authority. The Act does not prohibit it from pursuing its remedies. The contract was ultra-virus because the PS, as agent of the state, had no authority to bind the state for so large an amount of works and services. It does not appear from the Act that there is any penalty imposed on the PS in this case. Even more compelling is the fact that the principal had been paid in spite of his lack of authority, but there is certainly no provision in the Act barring the claimant, an innocent party, from recovering damages on a quantum merit based on a claim for unjust enrichment.
He seems to be disagreeing then with what was said by Justice Nelson in the Ramhit case. In the quote in paragraph 28, he refers to the ordinance prescribing penalties for illegal performance.
I checked that, my lady. I checked that, and I did not find that that section imposed any penalty.
So you think that the Court of Appeal is right, and
I think the Court of Appeal was probably referring to the regulations which impose a penalty on some other officer, not in respect of this matter. In other words, there was no penalty imposed under the Act for if the PS acted outside the authority in awarding a contract.
Right, but there is somewhere a provision that deals with the imposition of penalties on some people.
If I can come to that later,
Yes.
Yes. But it's in the regulations, my lady, it's not in relation to the award of the contract by the PS.
Well, I would be interested to see that.
Yeah. So having dealt with having dealt with what the Court of Appeal decided, my respectful submission is that the local Court of Appeal took the position that having examined the Central Tenders Board Act, there would not have been a stultifying of the policy of the Act if a claim for an unjust enrichment was enforced. Maybe I should point out to the board that Lord Tolson in Patel and Mirza at paragraph 2 of his judgment anticipated that illegality can be a defense to a claim for unjust enrichment. He stated at page EB 913, paragraph 2, illegality has the potential to provide a defense to civil claims of all sorts, whether relating to contract, property, tort, or unjust enrichment, and in a wide variety of circumstances.
Mr. Maharaj, I mean, I've sat here and listened to what you're saying, but this is not a case about illegality. So why are we spending so long on the law of illegality? This is a case about lack of capacity or ultra vires contract.
I'm much obliged, my lord, but based on what my friend submitted, he was in effect submitting that the policy of the Act was stultified if a claim for unjust enrichment was enforced.
Yes.
Yeah.
I'm merely saying that that seems to me to be as if he's submitting illegality. But my submission is, this is not a case of illegality. My submission is that all that occurred in this case, and as the defense showed to the claim, it was purely, it was ultra vires, the act, the contract.
Well, I think as I understood Mr. Rowe's submission, it was, this is not a case of illegality, but in any event, there is a stultification of the act, even though we're within the realm only of an ultra vires or lack of authority, want of authority situation. So I don't think he's... I'm not saying one can't draw analogies, but this is not a case, as I understand it, of illegality. There's no sanction.
Okay. Well, my lord, if it is, it's not a case of statutory illegality or common law principles of illegality, then one looks at the, I am respectfully submitted having regard to what the Court of Appeal decided in respect of these cases and in respect of what the policy of this act is, which I will go into now at this stage, my lord.
Do you accept that in principle, the question is whether allowing the claim for unjust enrichment would stultify the policy of the Act? Do you accept that that's the right question?
No, my lord. I am saying that an enforcement of a claim of unjust enrichment would not stultify.
But you accept that the principle is, does it stultify the policy of the Act or not?
Yes.
Yes.
Yes. Yes. Yes. My lord, the Central Tenders Board Act does not state that the Central Tenders Board makes any decision to spend public monies on goods. And my learned friend has not identified any provision in the Act which states that the Central Tenders Board makes such decisions. In this case, the respondent was not at fault in the sense that there is no evidence, and it was never suggested that the respondent colluded or had knowledge that the permanent secretary was acting outside of the act. So, in effect, the respondent was an innocent party. And I think one can see from the cases, from the decided cases, that if the claimant is an innocent party and did not participate in the illegality or in the ultra-virus action, that is an important factor which a court must consider in determining whether the claim for unjust enrichment should succeed. As a matter of fact, in the case of...
we don't really have any, apart from what you've shown us in this pleaded case, we don't really have any evidence as to how the request for tender and the bills of quantity that were issued in this case differed from what would have been issued by the Central Tenders Board, or what the usual practice of the Central Tenders Board is.
What happened is that the way the case was pleaded, there was no defense raised in respect of those issues that have been. So it was, as I mentioned from the pleadings, my lady, it was straight on the basis that the permanent secretary did not, and it was an ultra-virus contract. And there has been no evidence led.
But that's now common ground, as I understand
Yes.
it. And that is that his entry into the contract is only ultra vires, as I've so far understood the Act, if the board was not the body that invited tenders and decided which tender to approve. And the Act seems to contemplate that once the board's done its stuff, the final contract can still be signed by somebody in government. So that the common ground before us that the Act was not complied with, so that his signature was ultra, must mean that the board didn't go through its usual tendering process. Even if the tendering process that was gone through had a remarkable similarity with it.
Yes, my lord, and I accept the fact, because I think that is accepted in...
Yes, so that seems to be common ground.
Yes, that's common ground.
But it's not, I mean, that doesn't admit a conclusion that in fact the board went through the whole process and the only thing that was done wrong was that the wrong person signed the contract.
No, I'm not... no. But where that is the situation, the court has to look at the policies which and the factors which are usually applied when one is considering perhaps the common law principles of illegality or matters like that. And what I'm submitting is that if one is an innocent party and did not collude, that is an important factor.
Well, it would certainly help me to see the basis in authority for the importance of the innocence of the innocent party or the lack of collusion.
If I could take you to the case of Ukadina and Judith Chikali, that is at page 800 of the electronic bundle. And that is a case in which the judge was dealing with statutory illegality and common law illegality. But then when there was no statutory illegality, and then Lord Justice Underhill...
Can you just help me with the page number? My 800 is in the middle of Ockroyd Trading and Shua Siot Louis.
Sorry, 888.
880.
888.
Sorry, 880.
No, 888.
888.
Thank you.
888.
Got it. Thank you.
But this is another case of illegality.
Yes, but I
think you're being asked, are there any cases on ultra vires lack of authority where the innocence of the claimant has been regarded as relevant?
Well, my lord, I was submitting that the same principle would apply in that if it is that there's an ultra virus contract.
You're saying the same principles apply across from illegality?
Yes, yes, ma'am.
Yeah. I mean, it might be said against you that that's a very bold proposition to equate illegality with lack of authority.
Well, my lord, I think that if one has to consider exercising a discretion in the circumstances of a case in which you have an ultra-virus action, an important factor would be in determining whether to exercise his discretion would be able to see the conduct of the parties in question.
Well, I can see if we were doing that, that might well be a relevant factor. But why is the decision in a case like this discretionary?
Well,
And we're not talking about equitable relief or something like that, where it would be discretionary.
Well, in my respectful submission, one has to look at the act which governed the contract.
Yes.
And one has to be able to determine whether the act does not specifically state that in the event that a party does not comply with the provisions of the act, and if the act does not provide that there would be some, the contract would be regarded void or may not be enforceable, or that a factor or the normal common law factors would not be considered, then the statute would have that. But where statute merely it doesn't expressly specify that the innocent of the party would not be considered in determining whether a restitution claim should be granted, I think that's an important factor that should be considered.
But you've got no authority for that, other than cases on illegality which have got different policies involved.
I'm sorry, my lord.
You've got no authority. That's just a submission without authority.
No, my lord. Yeah. And I was just going to refer the board to from paragraph 59 to 62 of that judgment, in which the Court of Appeal analyzed the facts, and at the end of it stated and decided that because of the fact that the claimant, if your lordship looks at paragraph 59.
Could you please just give me the electronic page again?
Paragraph 59 at page 904.
Yeah.
Thank you.
We therefore find almost at the end of the quote, we therefore find that the claimant did not knowingly participate in any illegal performance of a contract, and that following Woolston Hall, the illegality does not render the contract unenforceable. Well, the ultra-virus action should not render the contract unenforceable if the person did not knowingly participate in any ultra-virus action.
But you can't be submitting that. That would make the contract valid and enforceable. It's accepted that the contract is not valid and enforceable.
Yes, yes.
Irrespective of knowledge. That's the starting point. We're now on to a separate cause of action in unjust enrichment.
Unjust enrichment, yes. Yes.
So I don't, with respect, think you can go back to quotations about the enforceability of the contract and turning on whether or not there's innocence or no innocence.
Well, my lord, I must confess I have found no authority in order to say that the innocence of the innocent party is a factor which ought to be considered.
Well, it's a sort of equity coming with clean hands point. I suppose that's perhaps as far as it goes, that if there was evidence that they had colluded, or at worst paid a bribe to the permanent secretary, then clearly they couldn't expect equitable relief. Is that? It's not really a question of discretion, but
I would rely on the fact that the state did not put in any evidence to show why the court should not award an unjust enrichment claim. And therefore, if the claimant satisfied the elements of an unjust enrichment claim, the question which arises is that applying a proportionate test when one considers what the ultra-virus action is and the circumstances in which the contract was performed, whether it would be disproportionate in the circumstances to deny the unjust enrichment claim.
But again, the disproportionality idea has got no support in the context we're dealing with. If we were applying Patel and Mirza, a range of factors approach, the submissions would surely have to be entirely different. But what's being put against you is this is not a case of illegality. It's a case of ultra vires contracting, and that there is a strong policy in the Central Tenders Board Act that counteracts the prima facie unjust enrichment claim. Now, I'm not at the moment hearing what your answer to that actually is, because all you're saying at the moment is, well, the Act doesn't say anything about it. Well, we know the Act doesn't say anything about unjust enrichment, but that's neither here nor there. We're talking about the implication, that is, the policy underlying the Act. So what is it that you are putting forward in answer to the central submission that's put against you?
Well, my lord, my answer would be that basically, my answer would be that one has to use the principles of whether the Act prohibits the making of that contract.
Well, it does.
Yes.
We know that.
Yeah.
Well, it makes it void.
Yes, and if it does not expressly prohibit it, whether it impliedly prohibits it.
But it does it says a contract of this kind cannot be negotiated or resolved upon by anybody other than the board. And it's common ground, I think, that the board had nothing to do with this.
But my respect for submission, well, my respect for submission is the court, the local court, the Court of Appeal, considered that policy of the Act and held that the policy of the Act was not stultified.
Yeah, certainly.
Yes.
But what do you say the policy of the Act is?
I'm sorry, my lord.
What do you say the policy of the Act is?
The policy of the Act, the policy of the Act, I say that the policy of the Act is to provide a transparent process for the award of contracts by the state. The underlying purpose of the Act, in my respectful submission, is to provide mechanism for public procurement of goods and services for the government in an effort to promote that transparency and accountability. But the Act does not state that every contract entered into by the private sector has to comply with the provisions of the Act. In other words, it does not expressly state that it does not expressly prohibit the private sector from entering into contracts with the state. And it does not state that if such a contract is entered into, that the contract would not be enforceable.
Do you accept the...
Precisely what it does say.
Yes.
Sorry, that is precisely what it does say.
Right?
That is precisely what the Act says. It says contracts are not valid. We're not talking about contracts and validity of contracts. We're talking about a separate claim in unjust enrichment.
It's accepted the contracts were invalid.
You're not,
Yes, and we are not enforcing the contract.
yes.
So we are in effect asking that the claim for unjust enrichment be enforced. My learned friend is saying that the court can look at the policy of the Act and determine whether the policy of the Act permits a claim for unjust enrichment. And my respectful submission is that since that the claim for unjust enrichment is not prohibited by the principles, we are not dealing with the principles of illegality, statutory and common law illegality, I have to rely on principles of fairness and principles, equitable principles, in the sense that this person, this party to the contract was an innocent party.
Do you accept...
Sorry.
Do you accept Judge CPC's explanation of the policy behind the Act in his judgment?
That's, I think, 101 to 102 in the electronic bundle.
Yes, so he says at the bottom of that page, 101, that was the passage that Mr. Rowe took us to, as he said, getting closer to the policy. What I'm asking is whether you are happy with that as a description of the policy behind the Act. It's slightly different from the one you just formulated, but I just want to ascertain if there's a difference just in wording or in substance.
Well, it is correct that the Act provided the intention is to provide a procedure for transparency and fairness. But in my respectful submission, that if one is dealing with a claim for unjust enrichment, and the claimant satisfies the ingredients of the claim for unjust enrichment, and the policy in the Act as reflected in the Act does not expressly or impliedly prohibit the enforcement of such a claim of unjust enrichment, that is a factor which a court should consider in determining whether it would allow a claim for unjust enrichment.
But are you saying that if the Act had said, for example, private contractors are prohibited by this Act from entering into a contract with a government minister, and they must only enter into contracts with the CTB, that one might imply from that that they are intended to be precluded from either enforcing the contract or claiming an unjust enrichment, but the Act doesn't say that. It says the contract is void. I'm not sure whether that is the distinction that you're trying to draw when you say that the Act does not prohibit the entry into the contract.
Well, this is the point I think Justice Prasad was making, in that the Act ought to be revisited, in that if the Act had said that there is this Section 4 and the other sections which provide the Central Tenders Board Act, but the Act had said that any contract entered into by the private sector with the government not in accordance with this Act would be null and void and of no effect, that would have been a different situation in my respectful view. But where the Act does not state that, the court is faced with an unjust enrichment claim. In my respectful submission, the court has to consider what the Parliament intended. And when one looks at the Act, one cannot see either expressly or impliedly that the Parliament intended that any contract which was entered into, the individual, the innocent party, would not have his civil remedies available to him. If it is that the Act intended to take away civil remedies for anyone who entered into such a contract, then in my respectful submission, that would be part of the policy of the Act. But the Act does not say so. All that the Act said is that it provides a machinery of the permanent secretary as a matter of convenience and entering into certain contracts of a certain amount of money, and for the Central Tenders Board to consider offers and negotiate and consider. But the Central Tenders Board Act, the Central Tenders Board is not involved in spending money or in approving the spending of money. I mean, it's not in the process, but the Central Tenders Board, the Cabinet is responsible for expending public monies, and the Cabinet decides through votes given to a ministry or department. So if it is that the state intended to rely on the policy of the Act being stultified, in my respectful submission, the state should have raised that as a defense, and the state should have indicated the whole process on how the Act will be stultified. But the state is asking this board, notwithstanding decisions of the local court, which decided that the policy of the Act was not stultified to award such a claim, to reverse those, to in effect reverse those two decisions on the basis that on the basis of not pleading such a defense and on the basis of raising it, in effect, by pure submission. So from my learned friend's case, I got the impression, rightly or wrongly, that he was contending, that the state was contending, that it was a case of statutory illegality and the case was common law illegality. And nowhere in the defense or it stated that the state was contending that the ultra-vires contract would be stultified if the claim was enforced. And my Lord, from the points that my learned friend made at the end of his submissions, I would submit that Young and I'll come back to Young and the case of Young and the mayor, but in the appellant's case, at paragraph, just getting the appellant's case for me. At the appellant's case at all the points that he was making. In dealing with restitution, my learned friend making 6 points. Where it starts? That's 434, paragraph 6.
Yes.
In respect of that submission, he criticized the Court of Appeal in stating that the limitations placed on the Permanent Secretary's power to contract appeared best for purely administrative convenience. Our submission on that is that the appellant took that statement of the judge out of context, in that the Act permitted the Permanent Secretary to make decisions in respect of the ministries. That was to reduce bureaucracy and to enable timely decisions to be made by ministries. The proper context of Justice of Appeal Bureau's statement was contained in paragraph 21 and 22 of his judgment, in which he examined and detailed the underlying policy of the Act. In respect of what my friend submitted at paragraph 8, at page EB 435, in which the appellant submitted that Justice of Appeal Bureau was wrong to place weight as he did at paragraph 23 of the judgment of the Court of Appeal. The appellant submitted that the respondent's submission in which it submitted that the omission in the Act to provide specifically that legal and equitable rights arising out of a contract which were outward the provisions of the Act were unenforceable. We submit that that is a factor which ought to be considered by the court in determining whether restitutional relief should be granted. In the third point he made, at paragraph 9, page 436, in which he made reference to the case of Wassa and Sukhanand Singh, the important point that Chief Justice De La Bastide made, he recognized it was a different case, but the point he made in the case was that if the prohibition against enforceability it should be a matter of policy clearly spelled out in the Act. And that is one of the points that we are relying on, that if it is that was to be a policy in the Act, notwithstanding putting in the Act the provision of the Central Tenders Board and the process and for the Central Tenders Board to negotiate, it should expressly state that that such a claim for and unjust enrichment would not be enforced. I wanted to point out to the board that there are certain prohibitions in the Act, and that probably would assist the board in seeing that the Act expressly made prohibitions. What page? Where dealt with that in the submission? Sorry, my lord, could you give me that? Where dealt with the prohibition? Yes, I'm sorry. Yes. In the Act, at clause 16 at page EB 514. It expressly prohibited. I'm going to point out 2 or 3 instances where it expressly prohibited who cannot enter into contract. At clause 16.1 of the Central Tenders Board, by clause 16.2, any such person who enters into a contract to supply goods and services to the government is guilty of an offense and liable on summary conviction. And then at EB 525, clause 3 of the Central Tenders Board Defense Force and Protective Services Order, any officer of the Ministry of National Security or the relative of any such person.
Is this still the Act, or is this?
It's a regulation, isn't it?
No, oh.
16.
This would be regulations. What regulations? Central Tenders Board regulations. What clause it is? 16.1 and 16.2 and clause 17.
Where is clause 17?
Clause 16.1,
I've got
clause 16.2 and clause 17.
So this starts at page 516, and it says it's an order made under section 20A, is that right?
No.
It starts at 516. Yeah, it starts at 514. And the Central Tenders Board Defense Force regulations is at 516. And we are looking at clause 525, clause 17. We are looking at 525, clause 17.
525.
Of the order.
Of the order. A member of the committee or an officer of the
That's
ministry.
the Defence Force
Yeah.
provision, right.
And then at section 35, 1H of the Act itself, EB 503.
Sorry, page?
Page 503.
503.
503. At H,
What's this?
that regulations may be made, and H is one, prohibiting the entering into contracts for the supply of articles or the undertaking of works or services connected therewith with members of the statutory bodies.
So that's the empowering in the primary act of the subsidiary legislation, delegated legislation that we've just seen.
Yeah, of the prohibitions.
Yeah.
So
You say that form of wording is different from the form of wording that's used as regards these contracts.
yes. So I know that there's a distinction between ultravirus and illegality, and I know that there are rules which apply to determine whether a statute prohibits a contract. But in my respectful submission, and I would ask the board to consider that in determining how the court will construe an act to determine whether a claim for ultravirus would stultify unjust enrichment claim, the court may not exactly use the same principles, but the court obviously ought to consider using appropriate relevant principles, such as whether, if it was the intention of Parliament to prohibit someone who entered into a contract not in accordance with the procedure stated in the Act, that contract would be void and unenforceable, or even in respect of any claim for unjust enrichment, it would not be enforced. But one of the principles also that the board should consider is that where an act does not expressly or impliedly prohibit the civil remedies which a person can take in order to get redress for a civil wrong, that is an important factor. And that is a factor which operates in this case also in determining whether the policy of the Act would be stultified in the enforcement of a claim for unjust enrichment.
So that looking at clause 16 on page 514, which makes it a criminal offence for a public officer to enter into a contract to undertake works for the government, I think you would accept that if there was such a contract and the public officer then brought a claim for unjust enrichment, they might well be met with a defence to say, look at the wording of section 16, it quite clearly intends that there should be no relief at all.
Yeah.
But that, you say, is different from what was done as regards these contracts.
In other words, there is no sanction in the Act against the permanent secretary in contracting with a member of the private sector out of the Act.
Well, should we continue at, should we continue at 2 o'clock?
Much obliged.